philosopher. And Kelsen told us that we must separate what is from what ought to be. Now, a lot of us have important ideas about what ought to be. There ought or ought not to be a general anti-avoidance rule. We ought or ought not to recognise the corporate form. Now, those are important questions, but I try to focus on the prior question of precisely what is. Now, it may well be that having defined what is, we then realise what ought to happen, but I'm really trying to describe tax law, and the objective of this whole series of addresses is primarily to try to explain that tax law may or may not be somehow different from other areas of law. Not a question whether it should be different or necessarily what we do about it if it is different, but just try to explain how it is different. And so I'm focusing more on is than on ought, and following the line of Kelsen. Now, I have a series of lectures that I can address on this topic, and the one I'm going to talk about now is autopoiesis. Now, autopoiesis is contradiction, really. It's a positivist theory and it's a postmodern theory. You wouldn't think there could be both, but it is. And autopoiesis tries to define what law is. I find it useful because it helps to illuminate the nature of tax law. Now, if we look at the antecedents of it, we start with Bentham, who said that law is essentially a series of norms, commands from a sovereign. Austin adopted what Bentham said. We thought that Austin thought it up himself until Bentham's papers were discovered in the 1970s, and we realised that Austin had in fact followed Bentham. And Kelsen saw that the Austin-Bentham thesis was deficient because it did not explain international law. Remember, international law is not the command of a sovereign, so how can it be law? So Kelsen had a different positivist theory. He suggested that law was a hierarchy of norms, but his problem was that when he got to the top of the hierarchy, there had to be a fictional norm that he called the Grundnorm, which essentially said law is to be obeyed. And two German philosophers, Luhmann and Teubner, they have tried to work out some way of explaining law that goes beyond Kelsen and is not reliant on a fiction. And they adopted this idea of autopoiesis, which means self-reproduction. It comes from biology, where a couple of scientists from Chile, Maturana and Varela, explained biological systems in terms of circular, self-reproducing, separate systems. The difference that they had from the perspective of biology was that until then people had thought of biological systems as being interrelated. Maturana and Varela presented them as being separate. And German sociologists, led by Luhmann, thought that this was a useful metaphor for society, and then Luhmann was also a legal theorist. He imported it into law. And in law, what they present is that law is a self-generating, self-referential and recursive autonomous system. It creates and renews itself. It has limited contact with other social systems. So sometimes it works and sometimes not. Not right. We have a picture of a number of circular, separate systems. Now, the impact of this theory has been very limited in common law jurisdictions. nobody pays much attention to it at all. And we contrast that with the impact of Kelsen, which we do look at. But my hypothesis is that although in the common law countries we're probably correct not to take much notice of the autopoiesis system, I suggest that it is, oddly enough, quite a good explanation of tax law, although not much of an explanation of law in general. Now, for positivists, the basic units of the legal system are essentially norms. And you remember that in Kelsen's view, the law does not contain any value judgments. That was his pure theory of law. Then the Luhmann and Teubner autopoiesis theory is sometimes called systems theory. And they say that law is like other social systems. Law comprises not norms, but communicative events. So essentially, they describe law as a system of communications. And what do these communications do? Well, they change legal structures. And they emerge as, say, statutes and contracts. And statutes and contracts, of course, change the relationship between people to whom law applies. And the relationship between legal acts, which they call communications, and legal norms is autopoietic, that is, self-creating, and it is circular and recursive, that is, in spirals that goes back into itself rather than relating to, say, the economic or the political system. And they describe the system as being operatively closed. So that is, the legal system reproduces its own elements recursively within itself. It is essentially closed to other social systems, separate and autonomous. And if it is separate and autonomous, that means that within law, the legal system decides for itself what is a fact. So it defines nature, as it were, in its terms, not in the terms of nature. And it then decides whether a particular fact is legal or illegal. Now, my suggestion is that within tax law, it is better to think of it as a code that we understand as saying something is taxable or non-taxable, or deductible or non-deductible. You could reframe it as legal or illegal, because you could say, well, the taxpayer has treated this receipt as non-taxable, that is illegal. And so you could reframe tax law in terms of legal or illegal, but it is a bit more helpful to go straight to this label that we are more familiar with. Now, this idea of a code that I've mentioned briefly is an important metaphor within the theory of autopoiesis. It suggests that all systems, all social systems and all legal systems can be defined in terms of their own binary code. And the code of one system distinguishes it from the code of another. So the question of legal and illegal, or taxable and non-taxable, we can understand that code within law, but we can't understand it within, say, the economic system. And we had an example of that yesterday, where we saw, as Menahem pointed out to us, that from an economist's point of view, there's no difference between evasion, avoidance and mitigation. That the code of the economists does not recognise those differences, whereas the code of the lawyer does. So a code then both operates its system and it distinguishes the system from other systems. And the way they put it, they say a system is closed as to its code. Now, for Teubner, who was and is Luhmann's follower and developer, for him the importance of the code is more than just a metaphor. It's integral to law. And he says that the legal system's autonomy is endangered when the legal coding is in danger of being replaced by criteria of economic utility and political expediency. So what he's saying there is that if the rule of law is breached by considerations of the economy, then law ceases to be autonomous and we have to be worried. Now, neither Luhmann nor Teubner has thought at all about applying autopoiesis to tax law. But if they did, I would suggest that they would regard a general anti-avoidance rule as a threat to the autonomy of the legal system, because a general anti-avoidance rule says to us, look at substance rather than the form of the law, and it's a kind of Trojan horse that goes into and attacks the formality of the law. Now, these code values that I've mentioned, that is legal and illegal, they are really conclusions rather than criteria. These values, legal or illegal or taxable or non-taxable, they cannot by themselves tell us whether a particular thing is legal or illegal. They cannot tell us whether a particular receipt is taxable or non-taxable. The philosophers of autopoiesis say we must have another element, and that other element they call programs. And programs in this context mean constitutions, statutes, regulations, court decisions and contracts. So those programs tell us how legal matters will be decided, and they decide the legal matters according to the code of the legal system, which is either legal or illegal, or in our case, taxable or non-taxable. And the code, they say, closes the legal system. They talk about operative closure. Legal system is independent of other social systems. Teubner explains it this way. He says, law can operate only within its own boundaries. But nevertheless, and this is the tricky part, it opens itself to its environment by constructing its own legal reality. Now, what's he mean by that rather obscure remark? Well, he says that the legal system, although operatively closed, is also cognitively open. He explains that systems do not exchange inputs and outputs. So you can't shift directly from the economic or political system into the legal system. But they can observe each other and they can react. They cannot communicate with each other directly, and if they present their internal communications to each other as noise, and they are indifferent to the bulk of each other's communications. So the same example that I mentioned a couple of minutes ago illustrates the same point. That is, from the point of view of an economist, there's no difference between evasion, avoidance and mitigation. But a lawyer regards the economist's conversation as almost irrelevant. It's just noise that we ignore, and we know that there is a difference between evasion, avoidance and mitigation. Difficult to define, but we certainly agree that there is that difference. Now, although generally systems ignore each other, every now and again they come up against each other, causing what is known as irritation. And when there is sufficient irritation from another social system, there may be new or amended programs. So if a social system, not the legal system, gets sufficiently irritating, as it were, to the law, then this noise may cause a variation of program. And that may well occur in Italy. If people get sufficiently cross with tax avoidance, they might pass a general anti-avoidance rule, or in some of the countries that Thomas was talking about. That would be an example of noise changing a program. Now, when this happens, according to the autopoiesis theory, what's happening is there is structural coupling, which is a strict term of autopoiesis theory. And legislation, for example, is the result of structural coupling between law and politics. And another example would be to interpret a contract in the light of the economic environment. So, for instance, suppose we adopt the idea of unconscionable bargain. Generally speaking, in the common law, we do not pay any attention to unconscionable bargains. If you manage to persuade somebody to sell you something at a price that is too cheap, well, that's your good luck. We do not revisit that bargain because it's unconscionable. But sometimes the common law might say, yes, we will, because the economic environment is such that we should not recognise this contract, or the social environment. We might say the person from whom you bought that house was a poor old widow who was suffering from Alzheimer's disease, and because you paid her only €80,000 when the house was in fact worth 200,000, we will say that's an unconscionable bargain. So that is an example of irritation changing a program within law. Now, Luhmann in this context emphasizes law's autonomy, but by the autonomy he means that law is self-defining rather than self-governing, because the law is to some extent governed by outside influences, by parliaments in particular. But I suggest that Luhmann's theory is not really necessarily true of all law, but it is, it seems to me, true of a lot of tax law. Other people criticise Luhmann too. They say that law is much more closely coupled with other systems than Luhmann will recognise. So this concept of different systems, independent operations, is an inaccurate and misleading picture, they say. In fact, there is much more interaction between systems than Luhmann would recognise. Probably the best Anglo-American commentator is Baxter, who's written a couple of very good articles, and he says that the focus on separate systems does not really give a very useful or accurate picture of law. He says that Luhmann gets away from events which are much more important. For example, he points out that you might have what Luhmann would regard two events that are just one. So if there is a payment, Luhmann would say, well, payment is important for the economic system, it's important for the legal system, separate events. Baxter points out that that's rather misleading. There's usually just one event. And Baxter gives many other examples where Luhmann would say there's perhaps a bit of structural coupling, but Baxter would say this coupling's going on all the time. Ideas of the corporation, ideas of competition, ideas of liability. Now, but I would say, though, that as far as tax law is concerned, Luhmann is onto something. Because in tax law, we do separate legal events and economic events. Even though the same event, we treat them as differently. So my argument is that in tax law, there is in fact little structural coupling with the economy. Of course, Parliament often remedies this when we have something that isn't going right. Parliament will pass a law, as we saw with Higgins and Smith. It was the Congress that passed the law where the legalistic answer might well be that Smith should have succeeded, but he in fact didn't in that case. But in some other common law countries he might have. Well, Parliament passes what they call, or what Fuller would call, an analeptic fiction. That is a fiction that repairs a problem. So you might treat a hire purchase or transaction as a sale. So take a hire purchase transaction. Tax law will tax a hire purchase transaction as a lease. Now that's an odd sort of result, because in fact a hire purchase transaction is essentially a sale. The reason why law constructs it as a hire purchase is simply for security for the vendor. And so it makes sense to treat a hire purchase transaction as a sale on credit, and indeed that happens in many tax systems. So we have a rule in the statute that says this may be a hire purchase transaction, but we're going to tax it as if it were a sale on credit, which is essentially what it is. That is an example of an analytic fiction. Now, take an example, however, of the point that I'm making, where economic and legal events, which are one event, get separated. A recent House of Lords decision is the Westmoreland case, where a subsidiary was in debt to its parent company. And the parent company lent money to the subsidiary to pay interest. And the subsidiary returned that money. Now, the question was, had there been a payment of interest? That's the issue. Was the interest paid? And the House of Lords says, yes, legally it was paid. That is, even though the parent had lent the money to the subsidiary, and the subsidiary returned the money, the House of Lords says that is a payment. Legally it was paid. And it was important to know that, because the interest had to be paid before it could be deducted. It wasn't enough just to incur it. But economically, nothing's happened. It's just like me taking some money from one pocket and saying, well, my right-hand pocket, that is the creditor, left-hand pocket owes money to it, so let's pass it over here and then pass it back. And there's been a payment. Well, economically there's been no difference, has there? It's just money passing back and forth, whereas legally that transaction is treated as a payment. So it seems to me that this is an example of what Luhmann talks about when he does regard one event as being in fact two separate events, a legal event on one hand, and in this case an economic non-event. And so Baxter's criticism, although it's valid through much of law, not necessarily valid in tax law. There's also an example of the point that I mentioned at the beginning with law creating its own facts, at least tax law. Because changing my money from one pocket to another and back, there's no fact there from an economic point of view. But from a legal point of view, there is a fact, as we see in the Westmoreland case. And that's an example of law creating its own factual reality, at least tax law. So, in respect of auto poiesis in general, I would disagree with Luhmann. I would say that the legal and the economic systems are much closer to each other than he recognises. And I'll give you a couple of examples in the development of contract law. Unlike civil law, in common law, took a long time for commercial law to develop, because executory contracts were not enforceable. Not enforceable until Slade's case in 1602. And what happened then was Slade agreed with Morley that Morley would buy Slade's wheat when the wheat was ripe and harvested. Mm-hmm. And when that happened, Morley reneged. And he said, no, I'm not going to pay. And under the common law, as it then stood, Slade had no remedy, because it was a promise for future action, and the common law would not enforce promises of future action. And all the judges thought to themselves, well, this, we have to admit, is a bit odd. So all the judges of the King's Bench Court and the Common Pleas Court had a big meeting together. And they said to themselves, we will do something about this. We are going to enforce that contract, which they did. So Slade won. First development of executory contracts, which is absolutely vital for the development of commercial law. Not a problem under Roman law systems on the continent, but it was a problem in England. And if anybody is familiar with the historical description of this, what happened was they assumed the assumpsit. But I won't go into what that means at the moment, but that was what was happening in this case. So that's one example. A more modern development in contract law is whether you need consideration for the variation of a contract. And the basic law is yes, you must, because if you vary a contract, that's a new contract, so you need new consideration. Well, in the case of Williams and Roffey brothers, which was about the middle of last century, Lord Denning invented what later became factual consideration. There was a change of a contract and it was enforceable. And more recently, in Anton's, Trawling and Smith, the Court of Appeal held that in a modern commercial contract there is no need for consideration for a variation. So that seems to me to be an example of more than just structural coupling. It is, both of those cases are examples of the commercial environment saying, well, law, you've got to catch up with what's going on, law has to change. And that seems to me to be a much more realistic picture of law in general. It's not really just noise going on. The courts change the law to reflect reality. And you can think of lots of miscellaneous examples where this sort of thing has happened. So the law of corporate personality, law of attractive nuisance, the defence of automatism, all completely random examples, but areas where the law has changed in reaction to social and economic developments. But in tax law, however, it seems to me that auto poiesis does have a role to play and an explanatory role, and which is somewhat counterintuitive because we think of tax law as being very close to economics, and we would think that tax and economics would be closely related. But oddly enough, the separation of the systems is very marked in tax law. We've talked about yesterday ectopia between the law as it applies and the target of the law. And Luhmann, he talks about this kind of phenomenon as a counterfactual fictions. So an example here is of autonomy and operative closure is, say, the concept of the source of income. Now, from a factual point of view, a non-physical object cannot have a physical source. It's just a logical impossibility. But tax law attributes a physical source to all income. That's the basis of the international tax system. Every item of income must have a physical source, and yet that concept is logically impossible. And we have lots of counter legal fictions throughout tax law, such as the hire purchase example that I gave. So it seems to me that tax law then does illustrate Luhmann's point about counterfactual fictions. And tax law is concerned about its own forms. It does not tax economic profits directly, but it taxes a legal description of those profits. And what it taxes is not a mirror of the profits, but a simulacrum. A simulacrum is a distorted mirror. So the legal description of profits is not the same as precisely what it is that the profits are. And judges and scholars recognise that this is so. So Justice Richardson said there are structures that have no reality under the statute except in relation to income tax. Something created just for income tax, a fact created just for income tax. And the American scholar Eisenberg has this marvellous passage where he talks about substance is form and little else. There is no natural law of reverse triangular mergers. You can't find a reverse triangular merger anywhere except in the mind of a tax lawyer. So, finally, let me give an example. The House of Lords case of Tucker against Granada Motorway Services. The issue in that case was, is a lease a capital asset? And the House of Lords said, yes, this lease was a capital asset. Now, they came to that conclusion even though the lease had negative value. The lease in question was not assignable. So even if it was worth something, Granada Motorway Services could not have sold it. Moreover, if Granada Motorway Services had put that lease into their balance sheet, that would have been a crime, because you're not allowed to put things in your balance sheet as assets if they're worth nothing. So they didn't. But nevertheless, even though from an economic and factual point of view this lease had no reality, no value, the House of Lords says, well, it's a capital asset, we treat it as a capital asset. So my argument is that this reasoning of the House of Lords is autopoietic. It is self-generating, self-creating. It does not rely on the economic system. It is separate from and closed to the economic system. So that's the kind of reasoning that suggests to me that this idea of autopoiesis does make sense as a description of tax law. Not much help in other areas, as I hope I've demonstrated by the contract law examples. But in tax law, it helps to show us that tax law is somehow odd and different. So I've actually used an unfair amount of time. I wonder if we should pass to Craig and then have questions and comments on both, rather than use up all that time. Is that all right by everybody? Or while Craig moves up, somebody might want to comment, but do you want to use this?
Yes, please.